All right, Matt.
Okay. The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. This is the Massachusetts Appeals Court. This is the September 7th, 2022 sitting of the Appeals Court. My name is James Lemire, and I'm joined this morning by Justice Singh and Justice Englander. We are calling 3 cases by Zoom, and then we will go to the courtroom and do 3 cases live. The first case this morning is City of Everett versus the Commonwealth Employment Relations Board. The Commonwealth Board and the union will be splitting their time 7.5 minutes each. Is that correct?
Yes.
And we'll start with Mr. Mason.
Thank you, Your Honor. May it please the court. This is an issue, and I'm sure you're well aware of it, about basically Chapter 152 statutory interpretation as a whole. In other words, it involves a chief, the appointment of a confidential managerial department head chief that's excluded from collective bargaining by Section 1 of Chapter 150, and also by definition of the employer and the employee under Chapter 151, 150E. The chief was selected through an assessment center, and the matter went to the DLR because it was addressed that the assessment center should have been impact bargained before it was used to select a confidential managerial department head.
But no one, counsel, no one contests now that the choice of the assessment center is something that's within the managerial rights of the city, right? That's not what we're talking about.
No, that's not what we're talking about. Well, basically what we're talking about is that when a situation is excluded from collective bargaining, to the best of my knowledge, it's only included into collective bargaining on an impact or means basis, unless the benefit for bargaining outweighs the detriment to the employer. And in this regard, the detriment to the employer, if you'll look at the second to the last docket entry, was that in the final analysis, that second to the last docket entry, which was honestly submitted to provide information for the court, basically took a chief that was appointed by that was appointed as an excluded managerial position and put him back as an acting chief. And to the best of my knowledge,
but that is not the, Mr. Mason, that is not the issue before us. The issue before us is that we're reviewing the
We're just
decision
going
of
to
the.
take one moment. I'm sorry, Judge Lemire. You got it working? Do you have her Zoom working?
Oh, which office? Is it Judge Englander's office?
No. Okay. Hold on. Sorry.
We're having,
Give me one moment. I apologize.
Matt, can you pause the time, please? Sorry, counsel, we're just having some technical problems. Judge Singh and Judge Englander were sitting together. One of their computers wasn't functioning properly this morning. So apparently IT is in the room trying to correct it. So just give us, we'll give you your full time, Mr. Mason.
thank you, thank you.
It's 12 minutes.
I'm back.
Okay. All right, Mr. Mason, we're gonna go back live.
All set?
Yeah. Go ahead. So Mr. Mason, what I was saying is we're reviewing the decision of the board. And the decision of the board is reviewed in accordance with Chapter 30A, Section 14. And that's the standard of review we apply. So I'd ask you to address under that standard of review, what it is that you're saying the board's decision is to be disregarded. Was it that it did not, it wasn't supported by substantial evidence, it was arbitrary or capricious, it was contrary to the law, it was an abuse of discretion? Which of those standards of review are you claiming that the board's decision did not comport with?
Thank you very much, Your Honor. My understanding of it was that in fact, there was no evidence submitted for the decision that they made that an assessment center should be impact bargained. What they basically are saying, that's number one, no evidence. Number two, that yes, it was an error of law because, as a matter of fact, you know, an excluded position was involved, and to subject an excluded position to bargaining has to meet the test, a balancing test, which they did not do as well.
Mr. Mason, counsel, can I just ask you, you talk about this balancing test, which, as I understand it, is basically articulates this notion that you have to balance the impact on the public entity against the interests that the union members might have. Has any court ever adopted that balancing test? Is there an appeals court decision or SJC decision that adopts that balancing test?
I believe there is, Your Honor, but whether even if
I did not see one, can I just say I did not see one cited in either brief.
Oh, all right. Well, I believe that the DLR uses that balancing test, and all I'm saying is,
well, the DLR doesn't make the law necessarily. I mean, we have some rules about what kind of deference we might give to that, but I would be interested in whether a court has ever adopted a balancing test under circumstances like this. In any event, this is an issue of first impression to the extent we're talking about a position that is not a union position at all, correct? There's no case that's ever addressed an issue like that.
no, sir, never, not in the private sector or in the public sector. And that's why it's my understanding that the public sector labor law is based on private sector labor law, and private sector labor law has never allowed an excluded position to be bargained, impact or otherwise. And in this regard, this position was specifically excluded. In addition, and worse yet, is that when in chapter 1073 of the Acts of 1078 of the Acts of 1973, when 150E came in, they specifically set up a separate position for interest arbitration for public safety department heads. And it was set, if bargaining was set up and they couldn't reach a decision, then it would go to interest arbitration. And interest arbitration, what they specifically said, could not, with substantive evidence, or could not address assignments, promotions, transfers, or minimum manning. This is a promotion. In addition, it was excluded by Section 1, and it's excluded from interest arbitration by, if as a matter of fact, there was an impasse being resolved. It couldn't be resolved because, as a matter of fact, it's a promotion issue. It's not something that an interest arbitrator could resolve through a JLMC. We don't see how it could be resolved through the DLR. And what we're saying is the public safety department head, CJAM, the Chief Justice of the Chief Administrative Justice for the courts, basically had a similar situation of transferring and personnel. And what was held that no, you can't require bargaining of that situation because of the security and safety of the classroom. And what we're saying, how then, when public safety has its own separate process and saying, for the public safety of the constituents of the community, how then can you require bargaining for that type of a position when in fact interest arbitration wouldn't even allow assignment, transfers, promotions to be resolved?
I don't understand. I did do a fair amount of looking at this. I've had some experience, but not enough. But as I understand it, police chiefs and fire chiefs are not even subject to civil service laws unless the town expressly opts in, right? And the city of
Yes,
Everett has expressly opted into that. But police
a
chiefs
local
and fire
option,
chiefs
right?
are managerial employees. They
Other
are
than
not
cities, it's automatic, but not by towns have to opt it in.
Towns have to opt in, cities is automatic. Interesting. Okay, I didn't pick that part up. So that shows my lack of knowledge.
Mine too. I have
But
to
in
look
any
it up.
event, the point is, and as I understand it, Everett has opted in. So the civil service laws apply, but they got a waiver in this case with respect to the civil service laws, so they could basically apply the rules that they chose to apply through a contract with HRD, and that's in the briefs, and that's also in the findings of the hearing exam. But they're managerial employees. They are non-union, and in fact, they sit on the other side of the table from the union, right? That's
Yes,
what
sir.
that's their job.
Yes, sir. That's what they're selected for. They're selected to represent. When I was saying section 1 excludes them, not only in the employee section, but in the employer section, because in the employer section, it says that any designee of a city or town is an employer. And as a matter of fact, you to subject choosing a designee to represent the interests of an employer is, as far as we can see, it basically outweighs any ancillary issues that the DLR has said should be bargained.
If I could interrupt for a moment, who made the decision in this instance to limit the possible applicants to deputy chiefs of the department, and how was that communicated?
That is a civil service process with a delegation agreement. There are options in a delegation agreement, and you can choose a particular option. In other words, as far as the experience you're looking for.
But surely they could say, surely the city of Everett could have said, we're not going to limit this just to folks who are already in the department. We want to look outside of people who are in our fire department. Surely they could have said that, right?
Absolutely, Your Honor. They could have opted for an open exam statewide. In addition, under Chapter 41-1080, they could have opted to have a contract chief. They did not have to go to the bargaining unit to pick an individual. They could have had a contract chief. They could have opted for a statewide selection process. And if there was a statewide selection process, there's no rationale for having the local group be able to bargain ancillary procedures that would go with it. You're absolutely right. It could be open. It could be contract. One of the in your area, the Boston area, they're a perfect example. The O'Toole report way back when basically said that, as a matter of fact, Boston is not diversified enough. And this Boston in-house group is not diversifying. They're not, as a matter of fact, selecting the proper people in relation to the community that they're serving. So Boston said, we're not going to pick from within, and we're not going to pick an open process. They went nationally and picked a commissioner nationally, changed the label from chief to commissioner, and put them in to address the problem of their community, which was diversity. And
there are other problems as well. We're familiar with them. They're in the papers. There are instances where an entire organization comes under fire and a decision is made by the person above that entire organization that they need to bring in somebody from outside. So in any event, that's why I was asking the question.
Yeah, and this is the concern of the city of Everett from the point of view of, we went to an internal process. We didn't have to go to an internal process. We could have had gone statewide. We could have done a contract. We could have done all of that. And then all of a sudden they're saying, no, when you use this process, you had to bargain it because it's our process. Well, it's not. We agree that within the confines of what the DLR called a career ladder, and that we'll bargain an assessment all of the time, anytime, for within the career ladder. But a career ladder ends with the representatives that by the union.
Can I just
Chief.
follow up? We're running out of time. Can I follow up on Judge Mears' question on the standard of review? What would you say is the error of law that was committed by the CERB in this case?
No, that's exactly what we're saying. We're saying it's an error. It's an error, not only an error of law, it's unsubstantiated by evidence that meets their own balancing test, if you will.
But what would you say is articulate for us the error of law that the CERB committed?
The error of law that they committed was choosing to get involved in the selection process of a position that is specifically, not generally, but specifically excluded from collective bargaining by the statute itself.
Your time is up, Mr. Mason, but I do have one follow-up, just a housekeeping matter. In August, you submitted or resubmitted your brief with some additional information in it. It was opposed. We requested that you respond to the opposition. I did not receive any response from you. Did you respond any further to their opposition when you requested that the brief be refiled?
I did not receive if you had requested a response, I was unaware of it. I had asked.
It was in the notice that you received, or should have been in the same notice that you received, that we were going to do this by Zoom.
Oh, if it was in that, I had assumed that.
So it's highly unusual.
To a Zoom. I did not see that.
Mr. Mason, it's our rules don't necessarily let you refile a brief and respond. I mean, you can have a reply brief, but you simply asked to refile your brief.
Yes, sir.
Are you suggesting that the additional information would be more aptly termed a reply brief?
Your Honor, no. From the beginning, from the very beginning when we started this.
All right, so you're not asking that information be considered.
No.
All right.
We're not, all I'm trying to do is again, have the opportunity.
It's improperly filed, sir. It's improperly filed.
All right, thank you. I'm sorry.
Who's going first on the other side? Attorney Cantini?
Yes, Your Honor, Lon Cantony.
Go right ahead.
Okay, may it please the court, Lon Cantony on behalf of the Commonwealth Employment Relations Board. Section 10A5 of Mass General Laws, Chapter 150E states that employer commits a prohibited practice when it refuses to bargain in good faith with employees' exclusive bargaining representative. Here, the SIR properly found that the city violated Chapter 150E, Section 10A5, by failing to bargain with the union over the impacts or the means of implementing its decision.
Well, what 10.5 says is that it's a violation if they refuse to bargain over a subject identified in Section 6. Right? It's not any bargain. They have to bargain over a subject identified in Section 6. What's the subject identified in Section 6 that they refuse to bargain over here?
Section 6 states any terms and conditions of employment.
Exactly. Let's take terms and conditions of employment. What is a term and condition of employment that was implicated in this case?
Well, here was the promotional process.
Why is the promotional process to a position that is not in the union a term and condition of their employment? These folks are seeking to leave the union. That is exactly their goal. So how is it how has anything been imposed on them with respect to their current job?
Well, here this is, it's a very narrow set of issues or aspects of the promotional process that the CERB determined imposed impact bargaining obligations.
Well, but you need to, I'm sorry, counsel, I know I'm being a little bit direct, but I struggled with this a lot because frankly, it didn't seem to be teased out in any of the materials I read. As I understand it, the law is that this has to relate to a term and condition of the employment of the union members involved. And yes, you've all cited the right cases, no question about it. But this particular issue is the one I think is critical, and it's a legal issue. How is this a term and condition of the employment of the union members?
Well, the board in the town of Danvers stated that the general topic of promotional procedures is a mandatory subject of bargaining.
Was that is that in the context of being promoted to a position outside of the union?
No, so this is admittedly a case of first impression, but there is CERB precedent to.
But isn't that an extraordinarily critical line that we have to examine and deal with? This is the first case that would say that the bargaining obligations in Chapter 150E apply when the person is seeking to leave the union and actually go across the table from the union to be the opposite of the union. This case strikes me as the union seeking to control who it is who's in charge of them. And that I find, even if, you know, the notion that, oh, it's only some small pieces, but to me, I find that on the wrong side of the line, counsel, and you're gonna have to explain to me why I'm wrong.
Well, Your Honor, the cases that the CERB cited have consistently held that promotional opportunities are of the utmost importance to these particular bargaining units, employees. It's the possibility of increased pay, benefits, job satisfaction. That was in the Boston School Committee decision. And so it's not a leap. There's been established precedent with the Boston School Committee decision, and then following that in 2015 with the Town of Arlington decision, and where the board found that the use of an assessment center as part of the procedures for promoting an employee from one bargaining unit to another was a mandatory subject of bargaining.
That's one bargaining unit to another. So that's going from one union to the next. And that would happen, for example, I was general counsel for the Mass Bay Transit Police, right? And they had separate bargaining units for patrolman, sergeant, and lieutenant. And yeah, I can see when because those are all separate bargaining units, but they're within the same organization and they're all union, I can see it. But here we're talking about somebody who is truly management, right? Excluded by statute.
And the selection of the chief is not what's at issue. The CERB acknowledged that the city has a managerial prerogative to choose to go with an assessment center instead of some other process for selecting the chief. The city has the managerial prerogative to determine the exercises used, the weight given for education or experience, the criteria or standards measured, how the assessment center is scored, and then the ultimate decision of who is selected. The narrow aspects in this case are the scheduling or the timing of the assessment center, the orientation or preparation process for the assessment center.
What is it that tells us, what law tells us that the union has anything, or the law regarding union bargaining has anything to say with how Everett chooses its management?
It's the means of implementing its decision to use an assessment center and the impacts of that decision. So while the city has, and the CERB acknowledges that they have this managerial prerogative, means and impacts are bargainable subjects, and the CERB utilized this balancing test that the city had referenced, and is the standard that the CERB has utilized since 1977, established in the town of Danvers test case to determine what are mandatory subjects of bargaining. And here, based on the decisions in Danvers, Boston School Committee, in the town of Arlington, the CERB reasonably used his expertise and technical experience to determine that for these very discrete aspects that the union identified, that there is no imposition or very little imposition on the core managerial prerogative of selecting the fire chief.
Can I
Whereas
ask
there is
you, you keep citing town of Danvers. Is this proposition of law correct? At least since 1977, the commission has taken the position that management decisions which do not have a direct impact on terms and conditions of employment are not mandatory subjects of bargaining.
Yes, Your Honor, that
What is the direct impact on terms and conditions of employment of the decision-making in this case? By the way, I was reading from a decision of the Massachusetts Appeals Court just then. Judge Drebin.
yes, so the direct impact on terms and conditions of employment is this very kind of once in a career opportunity to move up the career ladder. This is an opportunity presented only
that's
to
talking about a term and condition to leave their employment. That's what they're choosing to do. They are choosing to no longer be public employees as defined by Chapter 150E. They want to go to the other side of the table. How is it a term and condition of their employment?
Well, it's still the employment within the city, although they're not defined as employees covered by Chapter 150E by applying to the position.
Explicitly defined out. That's the whole purpose of the statutory language. They are not public employees.
And that takes them that takes them out of the scope of bargaining in terms of the criteria and the standards for selecting them for fire chief, but still these impact bargaining issues are still present. This could have prevented a person who was working for the fire department for decades and as a deputy chief for 15 years, Ragucci, from being able to, he could have been, these very narrow issues could have allowed him to apply for the position. Now, that doesn't mean that the city would have been required to select him by any means. That's not what the CERB was saying.
Well, in fact, as we've talked about with your brother, the city didn't even have to limit who they looked at just to this bargaining unit. They could have gone outside, right? They could have chosen to do this in any one of a number of ways.
Yes,
it was to the benefit of the union that they chose only to look inside the union.
Well, they could have chosen another. They could have chosen another method, but certainly they decided to go with an assessment center, and through that process, as Attorney Mason stated, the civil service at HRD requires that it's limited to the deputy chiefs. So
We're gonna have to cut you off there. Any further questions, Justice Singh or Justice Englander? Seeing none, Attorney Bryant.
Thank you. May it please the court, Patrick Bryant for the Everett firefighters. First, I'd like to begin with an argument raised in my brief that the city has waived all substantial evidence arguments. It didn't provide a transcript to the court. It didn't even provide the full administrative record. And because of the clear rules of procedure and case law on this matter, any issues challenging the facts are thereby waived.
But the legal issue that I've been addressing with your sister, that legal issue was raised, right?
The legal error issue, solely the legal error issue, but the underpinning factual findings of it, for instance, the impacts on the employees and the union, the comparative impacts on the city, those factual findings, we are bound by what the SERB found in that matter.
Okay.
The other thing that I would say is what's critically important here is in a case like this, this is a case of first impression, but it's not on a blank slate. We have the law that is phrased and cited by my sister counsel in chapter 150E, and the legislature has delegated basically to the SERB to interpret and apply that on an ongoing basis and to make refinements as necessary. The law has been in the SERB, for better or for worse, for nearly 40 years that promotional procedures are mandatory subjects of bargaining. The law has been in the SERB for better or for worse.
So slow down, counsel, slow down. But there is no case about promotion outside of the union.
Outside of the union to a managerial position.
Right,
that is correct. And I think what the SERB did is exactly what an agency is supposed to do in this area, which is let's look at our case law in this matter and apply those principles in terms for some kind of consistency. And they went through the entire history from Danvers, from Boston School Committee, from Town of Arlington, all noting that what had been done is indicated that promotional procedures are one of the most fundamental terms and conditions of employment for employees. So, but the promotional procedures.
What is the policy that would suggest that the union should have a say in how the person chosen to be on the other side of the table from them is chosen?
The policy is that in collective bargaining procedure, that when the applicants are limited to the members of the bargaining unit,
Okay, slow down. Where does that come from? Because that's interesting to me. You know, that in this case, the applicants are all from the union, but where's that? What case tells me that? That in the situation where only perhaps in the situation where all the applicants come from the union, then the rule is different. What case says that?
The idea is the way managerial subjects are determined and has always been upheld by the appeals court, including in the West Bridgewater case that both parties cite. These issues are made on a case-by-case basis. So it is fair in this case. What is only before the court is the situation where the union's interest, where the only people are participating are employees represented by the union. And when they sit for the promotional process, they are not managerial people. They have not left the bargaining unit. The fact that their intent may be to leave the bargaining unit doesn't change the fact that when they're taking that exam, they're all members of the bargaining unit. And the union's interest is they all be treated similarly.
Counsel, I'll let you be heard. Just slow down.
Sorry.
So they're sitting there, but they're sitting there by their own choice. So can we just try to tee this out? There is nothing that has been imposed upon them by the rules that we're talking about. I mean, in all of the other cases where there was a managerial decision but impacts were required to be bargained, I saw something that impacted the actual behavior of those people as the employees they currently were. Here, these folks have all voluntarily chosen to sit, right?
That respectfully, I disagree with that, because in all the cases that have dealt with promotional procedures, including the Town of Arlington case, including Town of Danvers, the individuals who were sitting for the exam, it was about them being promoted out of the positions that they were. It was not impacting their pay and compensation right then. For instance, assignments
Again,
that people have, those could be.
All of those cases are cases where, okay, I understand. All those cases, they want another union job.
That it doesn't pivot on whether that is another union job, but I'm really responding to the suggestion that because they are voluntarily sitting there, the union has no voice. There is no case, no doctrine that I'm aware of that has ever held where employees, where it is a voluntary option that it cannot be bargained. There can be situations like voluntary retirement, voluntary furlough. Lots of voluntary topics have been subject to bargaining obligations. So the real issue is the union, as laid out by the
It
CERB.
wasn't really what I was getting at, but I take your point, but it wasn't what I was getting at.
And I don't think one can look at what the CERB ruled as being subject to mandatory bargaining, and one can say that in any way the union would determine who is sitting on the other side of the table. The union's interest is in determining everyone is entitled to a fair shot and due process. So, for instance, the prep sessions that are held.
I understand the union's interest, but I mean, if the city of Everett had chosen, which they could have under state law, not to be governed by HRD, the mayor could have said, I want this person to be my fire chief, and the union would have had nothing to say about it. And that wouldn't necessarily be bad policy.
Well, we're not here debating the merits of that decision. We're here merely debating the ancillary aspects of this. So the fact that the city could have taken a decision that may have been better or worse on policy does not have a bearing on how the courts have interpreted Chapter 150E. We don't look at the opportunity costs of the decision that had been made. So in here, I think the relevance of everyone being limited to the bargaining unit is that different set of facts can be viewed differently by the CERB in another case. So if there was a decision.
Can I just ask, because I don't think I've got a satisfactory answer for me yet. How was the decision made and communicated that it would be limited only to members of the bargaining unit?
It was made by the city. I believe the acting chief, who was a bargaining unit member at the time, was involved in that decision. It was made at least 12 months or so before they notified the union, where they signed delegation agreements because of that.
So
and how was it I'm sorry, go ahead.
CERB's ruling would apply only in a situation in which all the you hearing some static?
Yep.
CERB's ruling would only apply in situations in which all the candidates for the assessment or exam are union members.
I believe that the case applies at least to the situation here, and a very capable management lawyer would be able to persuade the CERB it is limited to its facts. I'm not normally in the business of making cases to limit unions' bargaining rights, so I hope you can appreciate.
Well, it sounded like you were saying that in response to judging what you I'll suspect because if there's any further questions,
I have no more.
There's no rebuttal, Attorney Mason. You're on mute.
Your Honor,
All I would ask,
Your Honor, I would respectfully ask, in the record from the beginning, we had raised jurisdiction.
Counsel, there's no rebuttal.
I'm going to cut you off, Attorney Mason. There's no rebuttal. I control vote. It's been heard. It's under advice.
The case is now being recorded.
All right, good morning. This is the second case for September 7th, 2022. The case of Thomas Sheedy versus Goshen Mortgage, case number 2021 P605. Attorney Russell.
Good morning. May it please the court, Glenn F. Russell Jr. on behalf of the plaintiff appellant Thomas Sheedy, trustee for Liberty Trust. And I'm sure that your honors have read the briefs, so I won't try to rehash too much of that outside of the outline of the case. This is basically a quiet title action. However, it's predicated on the defendant's reliance upon a valid foreclosure sale in order to have superior title to defeat the plaintiff. And some of the issues involved during the trial court matter, the plaintiff wanted, basically the background of the case is that the plaintiff encountered Mr. Brown, Alan Brown, who was in financial difficulty, and Mr. Sheedy, on behalf of the trust, provided him a loan. In return for that loan, he took a second mortgage on the property. And subsequent to this, Goshen Mortgage at the outset of this case relied on a default judgment in case number 17 MISC 0651. And their position was that was a fait accompli based on that ruling. They had an equitable assignment of the mortgage and there was nothing to argue. The plaintiff successfully, at least as far as the trial court judge was concerned, argued reliance on Treglia v. McDonald, 430 Mass, 237, 241, 242 for the proposition that a default judgment, the issues are not fully litigated. So the trial court judge agreed that that was not a preclusive to the plaintiff going forward with its.
Counsel, is the default judgment the source of the assignment of the mortgage to Goshen as the current holder of the note?
Well, I believe, and my brother can speak to it better than me, but I believe their original position was that that default judgment rectified any problem in the chain of title.
But my understanding is the default judgment also, well, my understanding, which is confirmed by the decision of the judge, is that there is a judgment somewhere of a court that assigns the mortgage to Goshen because Goshen is the current holder of the note. Was that the default judgment that did that?
Yeah, that's correct, Your Honor.
Okay, but I haven't seen in any of your papers anywhere that you challenged that.
We did challenge that, Your Honor, and we
And
did.
on what basis do you challenge the assignment to them of the mortgage?
Under the default judgment or generally?
I look, as I read the law in Ibanez, it's absolutely crystal clear. The holder of the mortgage holds it in trust for the holder of the note, and the holder of the note has the right to go to court and have that assignment take place. And that's my understanding that took place here.
Right.
So on what basis have you challenged that, and where have you challenged that?
It's in the ruling, Your Honor. That is the basis of the Treglia v. McDonald. The judge agreed with my argument that does not represent.
No, I'm not interested in an argument about why the default judgment might not be binding on your client. Okay. Even if it's not binding on your client, it's binding against the world in terms of the assignment, isn't it? And your client would then need to say, here's why that was wrong. And I don't understand your client to have ever done that.
Well, I mean, then that goes into the history of the title, Your Honor, the history behind that.
No, I don't know that it does, because the only issue for purposes of the assignment of the mortgage on that basis would be who is the current holder of the note.
Correct.
Right. Do you, and I don't see anywhere in your papers that you challenge that Goshen is the current holder of the note.
Well, if in fact they were the holder of the note, Your Honor, and Your Honor is probably more aware of this than me, they could walk into the court today, and if they had the note, that doesn't mean that they can enforce the mortgage, because in Massachusetts, the exam.
You just shifted on me there, counsel. I would like an answer to the question I'm asking, which is, do you challenge that they're the holder of the mortgage because they are the holder of the note and they got a court order to that effect?
We challenged specifically that they held the note at the time of the auction.
Different issue, right?
I apologize, Your Honor.
It seems to me that's a different issue. If it's the same issue, explain that to me. I understand one of your defenses in this case is the foreclosure was invalid because they didn't prove, or they didn't, on summary judgment, sufficiently put in evidence that they were the holder of the note at the time that foreclosure was initiated. I understand that defense. I'm asking a different question, which is whether you're challenging that they are the lawful holder of the mortgage now due to the court's order based on Ibanez.
Not solely. There's two separate lines of attack.
Agreed.
Challenging on the title.
With respect to the Ibanez, I don't understand there to be a line of attack. If there is, you need to articulate for me now.
Well, I argued Ibanez, and the one of the issues is the chain of title to the mortgage. So, and that also incorporates Eaton, 462 Mass 569, Note 10, where they talk about the fact that a mortgage holder singly is only a resulting trustee that cannot take any affirmative acts. And we articulated this in the brief. So if you have an entity that is operating as a resulting trust, we don't know necessarily at certain times who is holding the note. And that is part of the issue of this case. And I mean, I didn't even get into the MERS argument yet, but I want to stick to your Honor's question. So it's not completely relying on the default judgment ruling because there are issues separate from the note. And if in fact they can, again, as I discussed, even if they have the note today, that doesn't mean they can enforce the mortgage. And Mr. Sheedy is different than a mortgagor. This is not a mortgagor case. If in fact Goshen establishes that they have a right to payment, Mr. Sheedy doesn't have to pay them. They would have to take that up with the estate of Mr. Brown. Mr. Sheedy's only concerned with the title. This is a quiet title action. So that's specifically the issue is who has superior title. They don't owe Goshen any money. So this is a little bit, there's a different flavor than a typical, foreclosure defense case. So I don't know.
The logic of why they have superior title, as I understand it, runs as follows. They were first. There was a first mortgage before your client's mortgage, right? Goshen then went into court as the holder of the note. This is the argument that I now understand and that was accepted by the judge. Goshen then went into court as the holder of the note and said under Ibanez, assign the mortgage to us because we are entitled to it. The court entered that order. They now have the mortgage and the note, and then they claim they then initiated foreclosure proceedings on the first mortgage. That's their argument, right?
Right. And the entry of the order, Your Honor, was a default judgment.
Right, but how else are they going to do it? I mean, all they're saying, we hold the note, court. Ibanez says that we therefore have a right. How else were they supposed to get that court order?
What's your significance that it's a default judgment? It's a final judgment, correct?
That's correct, Your Honor.
So because it wasn't litigated, it doesn't have any value?
Well, I'm relying on the ruling, Tregley v. McDonald, 430 Mass 237. Which
holds what?
I apologize, Your Honor.
What does that stand for? What is the proposition in that case?
The proposition in that case is that even if someone appears in that particular case, the person actually made an appearance, but the court said that because the issues were not fully litigated, it was not preclusive to later actions involving that same issue, which is exactly what we have here. And they said basically, because it's not fully litigated, it's not preclusive. And our court judge accepted my argument in that regard and denied.
But there was more than one issue. So it's not preclusive as to your client, right? But why isn't it preclusive as to GMAC, which was the holder of the mortgage and which was ordered by the court to transfer that mortgage to Goshen? Why isn't that preclusive?
Because GMAC was no longer in existence.
How else are they supposed to do it?
But within the title, Your Honor, there's assignments of mortgage that took place naming GMAC when they were not in existence.
But then as counsel, sometimes I find sort of indirect answers to what are very straightforward questions. I mean, GMAC didn't assign it because GMAC, the thing that says an assignment from GMAC, they didn't have it yet. So you can't assign what you didn't have. And we know this because there's an order from a judge that says this. This is what the judge below said.
Right.
So I'm back at this notion, GMAC ultimately got an assignment of the mortgage. GMAC, yes, it went out of business, but there was a lawsuit against GMAC, a final judgment, as Justice Lemire points out, that orders GMAC to assign the mortgage to the current note holder. Why is that not binding?
Well, I mean, if we go back into history, and I understand Your Honor thinks this, I apologize, I'm trying to be direct. GMAC, they had dependence upon MERS acting for an entity, right? And
Yeah.
And so I haven't had a chance to get into the Thompson argument, right? So the fact that this has never been brought up, and my brother argues vociferously that this case is, MERS is decided, and that's the end of the story. But none of the cases involved reliance on paragraph 16 of the mortgage. And I've been arguing this for—
There is an assignment that's recorded from MERS to GMAC with a particular date, and there's a recording of it, correct?
Correct.
And it predates the date on which the court entered its order, correct?
That's correct.
Why wasn't MERS, who was the assignee, I understand MERS to have been an assignee from Fremont, why wasn't MERS able to assign it?
The contractual provision at paragraph 16 of the Brown mortgage states that any language in the mortgage is subordinate to quote unquote applicable law, which is also defined as including final judicial rulings.
You say it's precluded by Eaton.
And Ibanez.
But those cases have to do with a different issue than who can assign a mortgage.
I would argue—
They have to do with who can foreclose on a mortgage.
That's correct, but Eaton did involve, specifically in note 10, they talked about affirmative acts. So affirmative act would include an assignment, and that's the argument. But the argument regarding MERS has never been fully ventilated. What provision in Massachusetts state law or applicable law or any judicial ruling would stand for the proposition that a mortgage holder could remain on the registry of deeds while the note is sold successively down the line without any further writings? That's completely in contravention of Massachusetts state law. There's
Well, wait a second. What policy would say that you don't want the mortgage to be able to catch up with the note? I mean, the problem that they addressed in Eaton was that the two can be separated, and that therefore, when they get separated, you can't foreclose properly. But what policy would indicate that you shouldn't be able to put the two together? In fact, that's exactly what Ibanez deals with. Ibanez deals with a situation where the two have been separated, and it says, here's what the law is. If you want to get the mortgage back to the note holder, go to court, and the court will order that because the mortgage holder holds that in trust for the note holder, right?
Right, but MERS is a different animal. MERS is a nominee, which we didn't even get into that. The SJC has twice opined it does not understand what nominee means in the mortgage context. Eaton at note 29, in a case I argued also before the SJC, Galeastro v. MERS, 467 Mass 160, note 19, they state that they don't have any idea what that means. There's never been a judicial ruling equating nominee with agency. So that if this court finds that MERS is an agent, we have to identify specifically what note holder they could act for. There's case law that states that, you don't need to identify the note holder, but that's pre-Eaton. All of and there's been there's a lot of confusion by the financial bar. They cite the cases that were decided after June 22nd, 2012, which was the prospective application of Eaton. The line of demarcation is the time of the notice of sale. So if you look at many of those rulings, the Wayne case is frequently cited to, the publication date preceded the prospective application. So, and I see that, I'm out of time, so I don't want to overstep my bounds.
Justice England, are any further questions?
I don't have any more, no.
Singh? I'm sorry, Justice Singh? Attorney Eicher.
Your Honors, good morning. And first, before I begin, I would like to thank the court for allowing me to appear at a Zoom hearing. This was something rather last minute, and it's very appreciated that I'm allowed to do so. And also, I want to thank my brother for agreeing with me to file the motion to do that. May it please the court, essentially, Mr. Sheedy is trying to get the foreclosure of Goshen Mortgage set aside on one of two bases. One is that they don't own the note, and number two, that somehow the chain of title of the mortgage was ineffective to them. In the lower court, it was determined that Goshen did in fact own the note based upon my affidavit sworn to that I have held the note, or my predecessor counsel has owned the note for a number of years. And indeed, on the first land court decision, the judgment in 2018 specifically mentioned that Goshen Mortgage owns the note. Sheedy,
Well, you had to have the note in your possession. Goshen had to have the note in its possession as of the time foreclosure was commenced, right?
Yes, sir.
That's
Correct.
2016.
No, Your Honor, the foreclosure was commenced in 2018.
2018.
Yes, Your Honor. And at that time, we filed a Section 35B affidavit to that effect. And also the first judgment of the land court, which came out in 2017, in its judgment, it noted that Goshen, asking for an equitable assignment from GMAC, held the mortgage. So Mr. Sheedy did not argue against that. He did not provide any contrary evidence to refute that assertion. And
Your
so
predecessor, you mentioned your predecessor counsel in your, this is helpful. So you mentioned in your affidavit, your predecessor counsel. That's,
Yes,
that's Mr. Cullen at Guadid and Benson, is that right?
yes, Your Honor.
And he, in 2017, he affirmed, at least through a complaint, that he had possession of the note at that
Correct.
time, right? And that was before the foreclosure was even commenced, is that right?
Correct, Your Honor. They saw, as the court here sees, that the assignment from GMAC down the line to Copperfield and Private Capital and Round Point failed because GMAC could not assign what they did not have. So that was the reason in 2017, an action was taken according to the rules set down by Ibanez, that we go to the court and say, court, we are the holder of the note. We request an equitable assignment be found from GMAC to Goshen Mortgage. The court found that we had a judgment without GMAC having appeared, the reason being that they were no longer in business. Mr. Sheedy has said that this judgment does not apply to him. However, I would point out to the court that, for one, under the rules of civil procedure, Mr. Sheedy was not a necessary party to the determination of the ownership of a note or an assignment. And secondly, as the court pointed out in the second land court decision, it's questionable whether Mr. Sheedy even has standing to claim that the assignment chain is faulty. Mr. Sheedy,
I have to tell you, I have a lot of trouble with that, but I'm not sure it really matters. I mean, he's got somebody he's got a mortgage. His client has a mortgage that they've foreclosed on, and they're of record as owning the property. He can't challenge the possession of the right to possession of your client in a lawsuit.
the only thing, it's a right to possession, yes. However, what is questionable and what we would challenge, and indeed this court in Gianasca and the land court below said that it is questionable whether he would even have standing to challenge it, because he does not claim that the assignment from MERS to GMAC is void. That is a statement which this court has given in the Gianasca case. But I will move on.
Well, okay, yeah, let's move on.
Very well, Your Honor. So given the fact that we, thank you. Given the fact that we were given the judgment in the land court case, the proper notices under 244, section 14, 35B filings were done, proper notices were sent out, proper publications were sent out, the sale was conducted, and Goshen Mortgage was the winning bidder, and we filed all the required foreclosure notice affidavits, Pinty affidavit, Eaton affidavit, and the like. So we foreclosed out Mr. Sheedy and Liberty Trust due to that. We were the holder of the mortgage, we were the holder of the note, we foreclosed, and we foreclosed them out.
Anything further?
That's the story, Your Honor.
Do you have anything further?
That is our position, Your Honor. We can go on about whether or not my brother feels that MERS has the ability to assign a mortgage. I believe that we have sufficient citations in our memo, which shows that MERS, especially when it is named as the entity which can assign a mortgage, can assign a mortgage. The fact that the Eaton case is cited by my brother is not applicable in this particular case because Eaton had to do.
Just stop for 1 second, because that's worthwhile for clarification. As I understand it, the original mortgage to Fremont has in it an assignment to MERS. Is that right? Is that where the assignment?
No, Your Honor. MERS was the original. Well, it was MERS's nominee for Fremont Mortgage. They assigned
the original mortgage is actually to MERS.
The mortgage is to MERS, and the lender is Fremont Mortgage.
Okay, so the original, the original document itself is to MERS with a right, with an explicit right of MERS to assign it.
Correct.
Okay.
So the claim that somehow Eaton or the Thompson case, both of which have to do with foreclosures, are not applicable in this particular case because MERS is granted the specific right to assign a mortgage.
And may I ask again, I'm sorry to interrupt, but
Please.
I think I get most of this, but I don't always get the facts because it's complicated. The only assignment to GMAC, the only one, is from MERS. Is that right?
Yes, Your Honor. There were two of them.
Yeah.
There were two. But I will point out, contrary to my brother, who did not challenge the appropriateness of either assignment under 54B, whereby both assignments were signed by an authorized signatory. At the time, they held the note, MERS held the note, and it was before a notary public. That satisfies the requirements of Rule 54B, and so therefore the assignment was made to GMAC. Now, my brother makes, shall we say, argument with regard to the fact that one may have been confirmatory to the other. The word confirmatory does not appear in either assignment from MERS to GMAC. And I would point out that this court in the Wells Fargo Bank versus Anderson case says that when there are two equally applicable assignments, they are simply confirmatory in nature.
So one of those assignments was, one of the assignments from MERS to GMAC was 2007. One was 2008.
Correct.
Was there any assignment of the mortgage by GMAC after the first of those, after 2007?
No, Your Honor. The only attempt they made at the assignment was down the chain before they were even in existence. So that chain of assignments fails. However, the note was passed by allonges to Goshen Mortgage, who by the time of their court case in 2017 before the land court, they held the note. And so thereby, under the Ibanez ruling, GMAC held it in trust for Goshen.
Got it.
Thank you, Your Honor. Any other questions?
Justice Singh? No? No further questions. Thank you, counsel. Case is under advisement. We appreciate your argument.
Thank you very much.
Thank you again.
The case is now being recorded.
All right, thank you. This is the third case for the panel on September 7th, 2022, the case of Commonwealth versus Bay, 2021 P979. Attorney Freed, go right ahead.
Thank you. Good morning, panel judges. I also appreciate this accommodation that you've made for me by allowing me to argue remotely. If it please the court, this court should reverse Mr. Bay's conviction on this single count of rape for either one of two equally strong, valid reasons. I'd like to address first the judge's use of the incorrect legal standard in determining whether the Commonwealth carried its burden of proof on the question of whether or not well, on two questions, whether or not the Commonwealth proved beyond a reasonable doubt that the complainant, I will only refer to her as the complainant at this for this argument and not try to use names or initials, was actually incapable of giving consent, and whether Mr. Bay reasonably knew whether they carried their burden of proof of showing that he knew beyond a reasonable doubt that she could not consent. The other basis would be trial counsel's ineffective assistance in putting forth a defense that was not tenable, not legally valid, and instead putting forward a defense in this case, that has been rejected time and again by the courts, the appellate courts of this state. First, to address the first argument, the judge's use of an incorrect legal standard, it's where we see the evidence of that in the trial transcript is during what we call the charge conference, or what the judge himself called the charge conference after the end of the evidence in this case, where he said, and I'm paraphrasing here, but it's close enough. He said, the way I understand the law, counsel, is that if the complainant was intoxicated and Bay knew she was intoxicated, that she was incapable of giving consent. No, neither of the attorneys in this case corrected that. And that's clearly an incorrect statement of the law. And many cases have said that that is simply reversible instructional error.
Well,
yes.
Is it an incorrect statement of the law, or is it simply an incomplete statement of the law? I mean, your sister says, look at the context there. The judge had before him all of the case law that explains that she has to be incapable of consent, not simply intoxicated, right?
Well, we don't know exactly what the judge was focused on or what the judge was paying attention to. It could be that, he had an entire law library and law clerks available at his disposal, but we don't know what he was focused on. What we do know, though, was that
we do know, don't we, from his ruling on the motion for new trial? He made it very clear what he relied on and the law that he applied.
Well,
what do we make of that decision?
Well, I do want to address that, but I think I want to try to answer Justice Englander's question first, which was the context, the immediate context at that time, which was the Commonwealth's motion to bar Bay from putting on an intoxication defense. And that was what that memo that the judge took back and said, I need to take a break and I need to read this. And then I want to talk to you all about it after I have a chance to read it. In that memorandum what the Commonwealth was focusing on and what the Commonwealth was arguing had to do with whether or not they had put on sufficient evidence of his level of intoxication to even be allowed to put on that defense. And they were arguing in that motion, not about what he knew, not about her level of intoxication, first of all, which is the first prong of what has to be shown. Their argument was his evidence of his own intoxication is too weak for him to even attempt to argue that he didn't know that he was too intoxicated to know that she could not consent. In other words, the Commonwealth, the context of that exchange had nothing to do with the first prong of the government of the prosecution's proof, which was, did they prove that she was incapable of consent? It was entirely addressed to the Commonwealth's position that Bay didn't put on enough evidence at all to show that he was entitled to use the second prong of that defense. And Justice Lemire, I think that this segues into the question that you just posed to me about what the judge was looking at in his decision to deny the motion for a new trial. How I want to respond to your inquiry there, Justice Lemire, is to say that, first of all, the position that the Commonwealth took in its motion for a new trial that this was the defense that Bay was putting on is completely contradicted and undercut by, first of all, the evidence at the trial, which would not have supported that. Two, that it was never argued. It was never argued by defense counsel. And in fact,
I read the argument yesterday and I thought defense counsel did argue it. I got to tell you. I mean, I thought defense counsel argued my client was too intoxicated to know.
He never says that. In fact, he never uses the word knowledge. He only talks about whether or not he intended to have sex with the complainant. And he talks about only that he thought he was having sex with his girlfriend.
But didn't Judge,
yes, I'm sorry, go ahead.
didn't Judge Callan indicate in his response, in his ruling on the motion for new trial, that he understood the defense to be that he was so intoxicated that that the defense was he was so intoxicated he couldn't appreciate whether she could give consent?
Well, I guess I know that this is not really a favored tactic in argument, but I think I want to respond to that with a rhetorical question of my own, which is, if that was the defense, why did not defense counsel, when the judge said, as I understand it, if he's only said, if Bay knew that she was intoxicated, that was the end of the matter and she couldn't give consent. If that was the defense, why did not defense counsel say, Your Honor, no, that's not wrong. That's not actually the correct statement of the law. The prosecution has the burden of proving that he was too intoxicated to know that she could not consent. And they had the burden of proving beyond a reasonable doubt that he knew or reasonably should have known that she could not consent. Those words never come out of defense counsel.
I understand, but didn't the judge say that's the law he applied in his decision?
I don't think he said that at all in his in the order denying the motion for a new trial. And in any event, I guess what I would say is that is a post hoc supplement of the record that is not reflected in the actual trial record.
Well,
the actual
can I just examine that for a second?
Yeah.
I mean, I understand the post hoc argument, and that's something we might have to deal with if, in fact, there was no indication in the record. But his closing argument did not make this argument. I agree. But when the judge initiated an argument about the law, I'm on page 67 of a transcript. I don't know which day.
Is that of day 3? I guess that was really when all
right. It's during this what he called a charge conference. Yeah, yes. Day 3. And I'm reading from defense counsel's statements to the judge. You should consider any credible evidence of mental impairment, this or the effect on the defendant, his or her consumption of alcohol or drugs in determining whether the Commonwealth has met its proof.
No, I know that.
Likewise, whenever the Commonwealth must prove the defendant's knowledge of any facts or circumstances, you should consider any credible evidence of mental impairment, the effect of the defendant on his or her consumption of alcohol. This was the argument he made after he presented the jury, the form jury instructions. I mean, isn't he making the argument to the judge, hey, my client was intoxicated?
I think that a fair reading of all of that, and this maybe I think bleeds into my ineffective assistance case, is that he's throwing out what sort of a general diminished capacity, he didn't mean it kind of a defense, because that's really the thrust of the argument that he makes when he actually makes his closing argument. Okay. This is not
whether or not there was a level of consent and consent was withdrawn. I mean, well, that's a different issue. I acknowledge that. Okay.
Yes, that is a different issue. But what he's maybe, and I forgot, I wanted to reserve a couple of minutes for rebuttal, and then maybe that's not even allowed at this point.
No, it's not allowed.
Okay. To try to get back to what you were saying, here is the problem, and this goes to the ineffectiveness claim. He argues, defense counsel argues in his closing argument, he thought he was sleeping with somebody else. He thought he was in bed with his girlfriend. He did not intend to have sex with the complaining witness. He says that over and over again. He didn't intend to have sex with this specific woman. He intended to have sex with someone else, which is a mistake of fact argument, but not a mistake, and it's sort of the same thing as a mistake of fact of whether or not he was having consensual sex. And that is the defense that cannot be.
But Ms. Freed, I'm not sure I completely understand your ad hoc comment, but
okay,
in the judge's ruling on his memorandum and decision on the motion for new trial,
denying the motion for new trial,
I believe on it's addendum page 60 or page 8 of his decision.
Oh, if I can.
Judge says, it was clear to me at trial, however, that although Mr. Bay's testimony was couched in terms of mistake of fact as to identity, the crux of the defense was that Mr. Bay was too intoxicated to discern whether EN was likewise too intoxicated to give consent. In other words, that if he were so intoxicated, he could not even discern with whom he was having intercourse, did not know and could not reasonably have known that EN was incapable of consenting and could not have formed the requisite intent. So the judge, isn't that a true application of the law?
Well, I would say, first of all, that in terms of forming intent, that's actually irrelevant. This is not a case where he had to form an intent to do anything.
The judge articulates that the defense, as he understood it, was that Mr. Bay was too intoxicated to discern whether she could give consent.
I would say this, that was never argued. I'm going to.
The judge used it as a defense.
Well, I think the crux of my argument, and this is going to sound disrespectful, not to the court, but to the Commonwealth, that is a fabricated argument. That is something that the Commonwealth fabricated in opposition to the motion for a new trial. There's nothing in the record to show that. I mean, the judge wrote a decision saying that, but if you go to the actual trial record, to what everybody said in the courtroom, not only did
I have to say, I thought I just read you something that suggests to me that that's exactly what defense counsel said. Now, granted.
But you don't see that in his closing argument.
No, it's not in the closing.
It's not in his closing argument.
It's about 10 minutes before the closing.
But you also know from reading his affidavit, you also know from, I'm sorry.
Regardless of what was explicitly argued, as the trial judge pointed out, isn't it implicit in the testimony that I thought I was sleeping with my girlfriend. Well, why would he be thinking that he's sleeping with his girlfriend? Because he's so intoxicated, he has no idea what's going on. And that bleeds into, he's so intoxicated that he would not recognize that the other person is too intoxicated to consent. That it doesn't matter what was explicitly argued. That is a fair implication. And that's what the judge was saying in his decision.
Well, I guess, Your Honor, Justice Singh, I would take issue that it does matter in the sense that one of the arguments we're making is an ineffective assistance claim, which is that if counsel doesn't make an argument that the court thinks he may be supposed to be making out of this soup of evidence, isn't that a problem? First of all, that he doesn't even articulate that is what the argument is. Number two, I think the fact that defense counsel says flat out in his affidavit in support of the motion for a new trial that he didn't want Mr. Bay to testify at all. It was never his intent to put him on. Without Bay's testimony, there would not have been a shred of evidence in this case about whether or not he was intoxicated at all, because none of the Commonwealth's witnesses testified to that. The only evidence that would be the extent to which there was some evidence of that in Mr. Bay's statement. So counsel could not have been consciously putting on that theory and at the same time trying to keep Mr. Bay from testifying in his own defense.
Well, but that he didn't. And Bay did testify. And again, I just took a look at some of the questions that were asked by defense counsel of his client.
Yeah.
And he asks him, did you know that it was Ms. No in the bed next to you? You know, he's asking him direct questions indicating A, that he'd been drinking, B, that he didn't know what was going on. Well, isn't he developing exactly that defense when he does that?
Your Honor, I would respectfully disagree that he's developing that defense. I think he's developing the mistake of fact defense. He's trying to develop a mistake of fact as to identity, which is what he explicitly argues. And that's the defense that can't work. He's not, I would respectfully disagree that is a fair reading of what was going on there. That he's arguing, I thought I was with somebody who was agreeing to have sex with me because I thought I was with somebody else. And because that person behaved as if they wanted to have sex with me. That person kissed me back.
But that is a defense, right? That's a consent defense.
Well, I'm saying that I am saying that that's right. He should have argued that this was consent.
I just started to read what he said to the judge on that. Granted, again, not in the closing, but 10 minutes before when they're in the charge conference, he said that there was evidence. Can I ask you a question?
Yes.
I thought that I may be confused about this, but we keep talking about this lack of knowledge as a defense. It's not a defense. The Commonwealth has the burden of proving that she did not consent beyond a reasonable doubt, right?
The Commonwealth has the burden of proving, one, that she didn't consent, okay? And in a situation where the Commonwealth's theory of the case is that she's too incapacitated to give consent, in order to avoid this sort of honest mistake idea, the Commonwealth has the additional burden of proving that the defendant could not have been mistaken about that.
Defendant knew that she
could not consent.
The Commonwealth's burden, is that right?
I'm sorry, say that again?
That's the Commonwealth's burden.
That is absolutely.
When the judge asks this question that you focused us on, the judge says, he says to defense counsel, what is the evidence?
Of consent?
That she consented. Yeah. And maybe we don't even have to get to the knowledge issue. He split the burden of proof.
Well, that's right. I mean, that's right. He said, I don't even know why we're here if there isn't any evidence of consent in the record. And what defense counsel does is put on, recapitulate what Bay said about the fact that, there was behavior on her part that I interpreted as consent.
Okay, thank you.
Justice Singh, anything further? All right, thank you, Attorney Freed.
Thank you.
Attorney Fisher?
Thank you, Your Honor, and may it please the court. My name is Aaliyah Fisher and I represent the Commonwealth in this matter. This case revolves around a confessed to rape that was proved by overwhelming evidence. Beginning first with the judge's instruction to himself, a judge is presumed to apply the law correctly and instruct himself correctly in the law during a bench trial. And as Your Honor rightfully pointed out, it's important to look at the context of all of the judge's statements. Not only does he make this statement as put forth by defense, but he goes on in his next sentence to say that he doesn't know if he needs to get to Ian's level of intoxication and his knowledge of it if there is no evidence of consent.
That's an incorrect statement of the law, counsel, isn't it?
I would argue that it's an incomplete statement of the law. It's not the full standard word for word, but this is not a jury.
He has to address the Commonwealth's burden of proof and find that the burden has been carried beyond a reasonable doubt. That in this case, the Commonwealth's theory, as I understand it, was she was incapable of consent, right?
That is correct, Your Honor.
And under those circumstances, hasn't your sister correctly identified what the burden of proof was? He has to reach that issue. The burden of proof is they have to show that she was incapable of consent, and they have to show that he knew she was incapable of consent beyond a reasonable doubt. Am I wrong about that?
You are not wrong, Your Honor. That is absolutely correct. My response to that would be that this is not a statement made to a jury. So he doesn't necessarily have to go through word for word exactly what the standard is. This is a conversation between a judge and two lawyers. Everyone in the room in a criminal court knows that, or at least all of the lawyers and the judge in the room know that the standard is beyond a reasonable doubt and that the burden is on the Commonwealth. It's more of a lax conversation than it is a strict jury instruction. The judge also points to two cases.
I understand that argument. That makes a lot of sense to me.
Thank you. The judge also recognizes Commonwealth v. Mountry and points out Commonwealth v. Schofield, which are both appellate court decisions that have the full standard within them. He states that he'll review and has reviewed Commonwealth v. Mountry and pulls Commonwealth v. Schofield on his own, showing that he is aware of this standard and had reviewed it before reviewing the evidence and coming to his verdict. The Commonwealth.
Counsel, can I ask, is your sister correct that the defense, I thought I was having sex with someone else? Defense may be the wrong word, but that the argument, that's not a defense to rape, correct?
That is correct, not on its own, but under these circumstances, making that argument under the couch that the defendant didn't know who he was having sex with because he was so intoxicated leads into the legally viable, and I guess we'll call it a defense. It's really an attack on the Commonwealth's evidence that he was too intoxicated to know that EN couldn't consent because she was likewise too intoxicated. So on its own, a mistake of identity isn't a defense, but it could be a part of the legally viable defense that the defendant is too intoxicated to know that the victim is also too intoxicated to consent.
If that's the defense that's being presented, if you will, now I'm using defense in the sense of what the defense is arguing. If the defense that's being presented is he was too intoxicated to know, was it ineffective assistance of counsel to fail to even talk to the other person who was in the room within hours of the rape?
No, Your Honor, I wouldn't say so. If you're speaking, are you speaking of Simon Kim? Just so I understand. As the judge pointed out, Simon Kim left the party before EN began to show many of her signs of intoxication. And when it comes to a crime like rape, because it occurs.
How did defense counsel know that? And isn't that in any event a contested issue even among the parties now, what Simon did or didn't see? He saw her throw up at least once because he says that in his affidavit. Are you saying it's consistent with a defense lawyer's level of practice that we would expect to have just foregone the opportunity to talk to that recipient witness?
I would not, Your Honor. I would say that we don't know. Sorry. I would say that we don't know what Bay said to his defense counsel at that time. Perhaps he told him that Simon Kim left and then these things happened. And so defense counsel already knew that anything Simon Kim would have to say would precede the rape by a matter of hours and be preceded by more drinking. So maybe under those circumstances, he would know that that testimony would not have any bearing. It doesn't mean that some defense lawyers wouldn't do that, but this defense lawyer chose not to. And I don't believe that's ineffective because Bay's testimony alone is what's relevant to Bay's knowledge of EN's level of intoxication.
Oh, you don't think that someone else who was in the room could have had evidence that was relevant to a finder of fact as to both the level of intoxication of the defendant and of the victim and the level of intoxication of the defendant?
No, Your Honor, I apologize. I misspoke. I believe under these specific circumstances, because Bay had stated, and EN had also stated that Simon Kim left hours before the rape occurred, that his testimony would have had very minimal impacts on the trial, if any. The fact, even if he were to say that EN was stone cold sober when he was at the party, the fact that EN was sober before she was raped, it does not mean that she was sober when she was raped. And the fact that
but if someone saw her sober 3 minutes before she was raped, that sure as heck would be relevant.
Absolutely, but that's not the
Okay.
circumstances we have.
We don't know the exact time of the rape.
That is correct, but we know it's hours at least after Simon Kim left the party, because it was, I believe, 11 p.m. when she left, and the rape happened at some point in the night before 5 a.m. I don't know. We don't know exactly when she went to bed. We know it was at least an hour after Simon Kim left, and that there was more drinking during that hour.
Your sister basically says, look, the defense that should have been raised was a defense that that the level of intoxication was not sufficiently established for the victim, and that that the defendant did not know or understand that level of intoxication, even if that were sufficiently established for a finder of fact, right?
Yes.
And where do you say we find that defense being raised in the transcript, as opposed to what the judge says subsequently, as Justice Lemire has pointed out? Where do we find that defense being raised in the transcript?
Well, I would highlight the defense counsel's questions to the defendant. As Your Honor pointed out, he questions him about how much he drank that night, and if he knew who he was sleeping with, how much EN drank that night. I would also point to the jury instructions and also the cases pointed out by defense counsel during the mock charging conference. He points out jury instruction 5.11 and 5.2, both of which would be the necessary jury instructions to raise that specific defense to a jury. He also points to two cases, Commonwealth v. Sherman and Commonwealth v. Kennedy. In those cases, the issue on appeal is that that specific defense of the defendant was too intoxicated to know that the victim was likewise too intoxicated is the only defense portrayed. And the court recognizes that as the only defense under those circumstances. By highlighting those jury instructions and those cases, he pointed the judge towards that defense, and he had laid the foundations for that defense during his examination of the defendant. While the Commonwealth agrees that his closing argument could have been more articulate or could have focused on this defense better, it's not the only evidence that was presented at trial. And the evidence that was presented at trial was understood by the judge, who was fact finder, to portray this defense, which was legally viable, therefore making his performance not ineffective. And even if the court were to disagree and were to find that the judge was wrong and that defense was not put forward, which the Commonwealth maintains the record reflects does show was put forward, appellate counsel would still have to prove prejudice, and there is no prejudice here. We don't have to speculate as to how the evidence portrayed by appellate counsel would have affected the verdict, because the fact finder heard all of this evidence on the motion for a new trial. He read Dr. Cohen's affidavit, he read Simon Kim's affidavit, and he looked at the DNA evidence again. And he said, none of this would have affected my verdict. I still would have found the defendant guilty. Therefore, there's no prejudice here, even if the court were to disagree with the Commonwealth as to the defense counsel's.
Are there any cases about this sort of post hoc issue? Are there cases that say that we're bound to accept what a judge who sat says in a bench trial context?
Not that you're bound to accept it, Your Honor, but there is a lot of case law about giving great deference to the decision of a judge who is deciding for a motion for a new trial when they were also the trial judge, especially at a bench trial. So, well, Your Honor,
the question isn't would it have changed that judge's mind, but it's more of an objective question, isn't it? Whether that judge, having sat through the trial, okay, so he's got that basis of knowledge, whether it would have affected, not that he personally would have made that decision, but that but that more objectively, any judge, that it really wouldn't have an impact given how the case was tried to begin with.
That is correct, Your Honor. My intention in highlighting the judge's motion for new trial decision was not to say that this is not still an objective standard. It is that we don't have to speculate specifically as to whether or not it would have changed this judge's mind. And that does play into the prejudice prong because it shows that the judge who was present at trial and heard all of the testimony and saw the witnesses in real time being able to truly judge their credibility had said that if I'd heard this evidence, it would not have changed my mind, which goes to that a reasonable trier of fact would not have found a different verdict had this evidence been portrayed. It's not absolutely decisive, but it is compelling evidence, I would argue.
But it's also supported, isn't it, by the evidence the judge did hear regarding the level of intoxication of both the defendant and the complainant?
Absolutely, Your Honor. As the judge pointed out in his ruling, there was overwhelming evidence as to Ian's intoxication. And
in other words, it's not unsupported by the evidence, it's supported by the evidence.
That is correct, Your Honor. And I would highlight for the court that the signs of intoxication pointed to by Judge Callan come from the defendant's testimony, which undercuts the argument about the DNA, because Ian's credibility wasn't the crux of the issue. Looking solely at the defendant's testimony, it is clear that Ian was too intoxicated to be able to consent because she vomited multiple times, couldn't get up from the floor, she was acting belligerently, making loud noises, slamming doors.
You think it's clear from the defendant's testimony that she was unable to consent? Doesn't the defendant testify that they were cuddling and kissing before the act occurred?
That is correct, Your Honor. The defendant.
So how is it clear from that testimony that she was unable to consent?
Your Honor, because there had been prior testimony about Ian's level of intoxication, it's the Commonwealth's position that she could not consent even if she was making those actions, that she was too intoxicated to be able to decide whether or not to kiss him back. She was too intoxicated to be able to understand what was happening.
That's not consistent with the defendant's testimony. The defendant's testimony was that she did kiss him back, that she engaged in cuddling with him. That I can't understand a position that says that as a matter of law, on that evidence, she was incapable of consent.
Your Honor, I would say not necessarily on a matter of law, but based off of all of his testimony, it was clear that she couldn't consent. Looking specifically at his statements on her actions, it's not required that a fact finder credit every portion of someone's testimony. They could have credited other portions of his testimony and not given much weight to that part of the testimony. And maybe that brings in some of Ian's credibility on she did testify. She didn't testify that she did those things. She testified that she'd been drinking and that she was vomiting and didn't remember much of the night.
I understand that. I was just questioning. I mean, it's funny because in a case like this where the assertion is ineffective assistance of counsel, the briefing at times starts to sound like it's a sufficiency brief. And it's not a sufficiency brief, right? We have to weigh all the evidence when we're looking at potential prejudice, which would include evidence that on a sufficiency review, we would completely disregard, i.e. the defendant's testimony. Okay.
Thank you, Your Honor. I would agree that it often turns that way. I would say my point in highlighting this testimony is just to show that there was so much evidence in this case that there wasn't a defense that is put forward today that the defendant was deprived for. There's a substantial grounded defense that could have been presented at this trial that wasn't presented at the trial. And therefore, there is no prejudice, even if the court found that the trial counsel's performance fell below what could be measurably expected of an ordinary fallible lawyer. I see my time is about to expire, so I'd like to see if there are any questions before I close.
All right. Seeing no questions, the case has been submitted. We'll take it under advisement. Thank you very much, counsel, for your argument.
Very well argued on both sides. Thanks.